Okay, so I think we can start now. Good evening. My name is Greg Perrick. I'm a review counsel, family law review counsel at Community Legal Services at Western Law. Tonight, I'm going to give a relatively brief but informative presentation on the basics of spousal support. We're also putting this presentation on in conjunction or in partnership with Rights and Responsibility Awareness Institute. So we thank them for boosting our collective signal about this public legal education seminar. So before we start, it's incumbent upon us to make a land acknowledgement before we start. So I acknowledge that Western University is located on the traditional lands of the Anishinaabe, Haudenosaunee, Anapewak, and Chinookan nations, on lands connected with the London Township and Sombra Treaties of 1796 and the Dish with One Spoon Covenant Wampum. With this, I respect the long-standing relationships that Indigenous nations have to this land, as they are the original caretakers. I acknowledge historical and ongoing injustices that Indigenous peoples, First Nations, Métis, and Inuit endure in Canada, and we at Western, myself, accept responsibility as a public institution to contribute toward revealing and correcting miseducation, as well as renewing respectful relationships with Indigenous communities through our teaching, research, and community service. This is not something that we just pay lip service to. This is something that we need to internalize and take seriously. So moving forward. Before I get into kind of the meat and potatoes of the presentation tonight with respect to spousal support, just a little disclaimer, this is not a legal advice session. I'm not giving you legal advice as a lawyer. I'm giving you legal education, public legal education, and it's going to have basic and general information with respect to spousal support. There are going to be many other kind of more complex and perhaps nuanced issues around spousal support. And throughout this presentation, I'll encourage you to obtain specific independent legal advice beyond that. There will be a Q&A session for those who may have general questions with respect to spousal support. But again, it's only going to general information or general advice that I can give. I can't give specific advice with respect to your specific circumstances. So please remember to keep your questions general. Also, because this is not specific advice, do not rely on it as some kind of legal advice and take that to court or take that to your specific matter. Again, I would encourage you to get specific legal advice from a lawyer. So kind of playing off of that, there is no confidentiality with any of the information that I talk about tonight. If you have any questions, again, I would urge you to keep them general because, again, there's no confidentiality. Whatever you say will be publicly recorded and streamed. For those of you that are watching on Facebook or what have you through Rights and Responsibility Awareness Institute, you'll recognize that this is being streamed live and public. So please keep that in mind. For public legal education, we sometimes have our law students do the presentation. When they would do it, they can't give legal advice. So if they were doing the Q&A, you wouldn't be able to ask them any questions. Tonight, I'm doing it. I'm a lawyer, not a law student. But again, keep in mind that I can only answer general questions and there's no confidentiality. Okay, so I like to start with spousal support, talking about the kind of document or the piece of law that speaks to spousal support. Spousal support is kind of handled by the Spousal Support Advisory Guidelines, or SAG, as some people like to shorten it up as. And as I've said there, it's a guiding document that assists separating parties and the court, if applicable, in determining what is the appropriate amount of spousal support, if any, in the event of a breakdown in a relationship. Some of you may know that child support, you have the child support guidelines, and in almost all cases, the child support guidelines is mandatory, meaning that especially in circumstances where you have one parent that cares for a child 60+% of the time, the only thing you really have to look at is the child support guideline and the payor's income. And there's no kind of discretionary element as to whether they owe the guideline amount or not. Child support, the child support amount is mandatory, and it's the right of the child. The spousal support guidelines, however, are not mandatory. They're guidelines in the truest sense. However, as I've said on the slide, the court does place significant weight on those guidelines because it's been around for quite some time. It takes perhaps a lot of the guesswork out of what the spousal support amount should be, if any. So the court, like I said, it considers the spousal support guidelines in a significant way. So I'm going to talk about just what I would consider the three main elements of spousal support. And I think that's the best way to kind of give basic information on how to understand how spousal support works upon the breakdown of a relationship. So as you can see on the slide, the three kind of main pieces of spousal support that we look at is first, entitlement, quantum, and duration. Entitlement, I will speak about. Quantum, as you will see, is just a fancy word for the amount of spousal support that is owing, depending on how it's owing, whether it's on a monthly basis or some other periodic basis, or on a lump sum basis. And then duration is for the amount of time that spousal support would be payable for. So let's look at entitlement first. So the court or the parties, if it's not in court, they must first determine if there is an entitlement to spousal support, if at all. The spousal support guidelines are clear that if there is no entitlement, if it's determined either through the parties and that's accepted, or if it's determined in court that there's no entitlement, then the kind of investigation ends there. There's no further question about amount or duration. If you're not entitled to spousal support, you're not going to look at those other elements. So how do we establish entitlement? There are three ways to establish entitlement. There's compensatory, non-compensatory, or needs-based, and contractual. I will go through first, compensatory entitlement. So generally, and most often, compensatory claims come into play with longer relationships where the rules in the relationship are more traditional. Now, that is that traditional relationship where there is, as you see on the slide, a breadwinner and a homemaker are going away, as you might expect, and for the better, I would say. But in this particular scenario, to highlight how this works, you can think of maybe a more, again, traditional, or we call nuclear family, where you have a clear breadwinner and a clear homemaker who stays at home. In this example, for compensatory, and think about compensating somebody else, the rationale or the purpose behind compensatory entitlement is, in this scenario, if one stays at home, if one parent stays at home and it's the homemaker, takes care of the home, makes sure it's in good working order, maintains it, cleans it every day, and does housework and so forth, and makes it possible for the other spouse to go out, advance their career, make more and more money, perhaps. In that scenario, the homemaker should be compensated for the work or the sweat equity that they put into the relationship. There is definitely well, no one's getting paid for their sweat equity. That should be recognized as creating a value into the relationship. And so that's what compensatory entitlement is doing, is saying, because of the sacrifices you made or the roles you played in the relationship, where one person worked and perhaps he worked less or not at all, you're going to get compensated at the end of the relationship, because otherwise you're kind of left with little to nothing. And obviously that would not be a fair, or what we would call equitable result at the breakdown of a relationship. Another example, and like I said in the slide here, similar to what I just talked about, is if there is a sacrifice of some sort, in terms of one parent works more, or is the parent that works, and the other is at home taking care of the children. One example could be a mother who has multiple children, and perhaps in succession, and so they were likely home, for 5 years or so, for the bulk of 5 years, having children, raising them, getting them ready for their school age, so they wouldn't be in the workforce. And yet the other parent would be, and there's going to be a compensation. There should be a compensation there to recognize for the sacrifices that the parent who was raising the children made to not be in the workforce, but to make it necessary, or to make it possible for the other parent to remain in the workforce and not have to be at home helping raising the children. There are, like I said in the slide, there are obviously other examples of this, but I think these two kind of relatively extreme examples give you a sense of how compensatory entitlement works. So the second way for entitlement through spousal support can be through non-compensatory, or better, I think, explained as needs-based. So non-compensatory entitlement, as you can imagine, it is for scenarios where there perhaps is not a clearly long relationship, and the roles aren't as defined. But at the breakdown of the relationship, there may be a marked disparity in the parties' incomes. And the objective of the spousal support guidelines, at least one of them, is to make sure that there is kind of, it doesn't have to be a full kind of equalizing of the parties' incomes upon separation, but what the court wants to do, at least for a limited amount of time, is to make sure that the lower earning spouse is given at least an amount of time where their standard of living during the relationship it's the same as post-relationship. One of the objectives of the guidelines, however, is to make the party self-sufficient, to incentivize gainful employment if there isn't one. So a time-limited order or agreement may be made in these non-compensatory claims. As I said in the bottom there, a strictly need-based claim, not in conjunction with a compensatory claim, but a strictly needs-based claim is more commonly made in shorter relationships, as I say there, because it's harder to establish if there were roles played in the marriage and if sacrifices were made. Quite often, though, and in the slide that the standalone slide I have, the reality is that for medium to longer term relationships, as I call them, will probably attract both a needs-based claim and a compensatory claim. So you would have a bit of sacrifices made, and you would have a bit of roles played in the marriage, but perhaps you also, because of that, you have disparity in income. So there may be kind of a double-barreled approach on that particular claim or claims. The third way to establish entitlement is through a contract or contractual entitlement. As the description makes clear, this arises when the parties have contracted, agreed to some kind of contract where they agreed that there would be a spousal support obligation from one spouse to another. I would encourage, now we did the other week, 2 weeks ago, we did a separation agreements or domestic contract public legal education. I would encourage you to go back and watch that, because I talk about at length, kind of the markers that should be hit if you're going to make a contract as solid as it can be. That doesn't mean it wouldn't be vulnerable to being overturned, but to make sure that you've dotted your I's and crossed your T's, so to speak. And a way to do that, and I'll just generally kind of go through it right now, but again, I encourage you to go watch the other PLE, Public Legal Education, on separation agreements and domestic contracts. First, you should make clear, when does the spousal support obligation begin, or when it commences, as lawyers will say. When it ends, if there is an applicable endpoint of the spousal support obligation. And I will talk about, in some scenarios, there isn't an endpoint. It's not a fixed term. How much is going to be paid on a monthly basis or a periodic basis? It doesn't necessarily have to be monthly, but that is the most common. Or there are scenarios where there's going to be a lump sum payment made by the parties or made by the spousal support payor. But if you're going to do a lump sum payment, as I said in the slide one, I would make sure if you could get financial advice from your financial advisor as to how that would impact you if you were being paid or if you are paying a lump sum. But one of the advantages of the lump sum is for what we would call a clean break, right? You don't have to feel bound to your former spouse anymore. You'll pay them a lump sum that will represent maybe the block of time where you owe X amount on a monthly basis, but you're saying, I will pay you this, and then we don't have to remain kind of tied together moving forward, because I won't be paying you on a monthly basis. Spousal support contracts or contracts in general for family law should include independent legal advice. You should be getting, if at all possible, advice from a lawyer. And I will talk about in a couple of slides later briefly about how, kind of the options for that. You should be doing full financial disclosure. Okay? And at the very least, in my view, folks, if they're going to be setting down some spousal support obligations, they should be exchanging their last 3 years tax returns, their last 3 years notices of assessments, and possibly, if at all possible, swearing to a financial statement, which is called a Form 13 financial statement, which can be found on Ontario Court Forms website. If you Google that, it should take you where you want to go. And the reason for this is because a contract, if there's no full financial disclosure, you worry about the fact that the other party could say, well, I didn't know how much they were worth, or maybe they get some evidence later that you were actually making X amount more, or you had benefits that could have been considered as income. The more financial disclosure you do, the less worry there is in that regard. So do full financial disclosure. It may be a pain in the butt, but I say this in the separation agreements and domestic contract presentation last week or 2 weeks ago. I say this throughout: short-term pain for long-term gain. Okay, you don't want to have, years later, an agreement being overturned in court because there wasn't independent legal advice or there wasn't full financial disclosure. Also, what you should ensure is that there's ample time to negotiate. Folks don't want to be, you don't want to rush either side, even though you may want that clean break. The reason for that is if you rush into something, either yourself or both parties may feel like you're being pressured into it, even if there's no explicit or specific words like, hey, are you done yet? You should hurry up. I need this done. We got to get this over with. Even if there is nothing like that, the kind of speed of it all would worry me. So make sure that you consider a contract thoroughly, and you give yourself and the other parties time to consider the nature and consequences of either letting spousal support go or getting spousal support. Any contract that you do, and hopefully it's at the guidance of a lawyer, it's also witnessed and it's also dated. You want to make sure that those things are present to really, again, solidify your contract as much as possible, so it's less vulnerable to being overturned if it's ever contested in court. Okay, so I talked about the spousal support contract should include, and I've talked about what the idea that a spousal support agreement could be overturned. Even if you have, and this is not a common occurrence, I will say, but it is out there. It could happen. Even if you have all of these 5 factors up top there, there's also the notion of unconscionability. And this is now I will say this is a very, very, very rare thing to be considered by the court, because the threshold, as we call it, or what the test they would have to meet to be able to say something is unconscionable, is they have to prove that this is something that shocks the conscience of the court. And that is an incredibly high threshold, as you can imagine. So to make sure that you are also addressing this issue of unconscionability, you should be making sure that the spousal support agreement has all of these 5 factors, but also it should have an element of, it should have the elements of being fair and reasonable. Now, that's not a requirement, but you do want to make sure that, people aren't being unfairly taken advantage of, because there is that possibility that there could, the court could find, if it's ever contested, that it was an unconscionable agreement. Again, this is a very, very rare, I think, exception that I have not seen I think I've only seen once in my career so far, but it is something to keep in mind. So quantum. So now we talked about entitlement. Now we'll talk about quantum. Quantum, again, it's just the amount. It's either the monthly amount, a periodic amount, maybe that's a quarterly payment, 4 times a year, or it could be a lump sum. Like I said at the top of the presentation, the amount is not fixed like the child support guideline. You just can't, cross-reference a table and say, okay, 2 kids, $40,000, and then meet it up so that you know exactly what the payor should be paying. That's not how the child support guidelines work. As the slide indicates here, the SAG or the spousal support guidelines will produce, when you do a spousal support guideline calculation, it will produce a high range, a medium range, and a low range. Case law, just generally, basically tries to tell parties and tell those who are seeking spousal support that it's not as simple as just saying, okay, well, the payor is going to want to have a low amount and the recipient who's getting support is going to want a high amount. So we'll probably just settle in the middle. While that may happen more often than not, it's not an automatic consideration that you go with the medium amount. Well, there are factors to be considered that could warrant a higher amount or a lower amount. And a spousal support is a bit more complex, or not a bit more, it is more complex than child support in that there are a whole host of factors that go in in determining quantum as well. So some of the things that I come across that may impact the amount of support is debt load. How much are the parties carrying? How much is the recipient carrying? How much is the payor? What has been the conduct through the parties, perhaps before court or at court? Or was there some lack of financial disclosure? Was there an active kind of evasion to say what someone's income was, or what their financial circumstances were? Or child support obligations. Child support obligations come before spousal support obligations. So just because there is an entitlement, that does not mean you may get the the warranted amount of spousal support, because first child support needs to be paid. Age of the parties. Do we have folks who are near retirement age, or do we have younger? This was a shorter relationship, and we have folks who are going to have their whole career ahead of them to earn money. Or the health of the parties. Do we have an individual who, a spousal support recipient who is unable to work or disabled in some manner or another, and maybe perhaps a higher amount of spousal support is awarded to address those particular issues. So it's certainly, the short answer is it's not a matching up of the charts and the rows and columns. It's a more involving process, and like I said at the top, and we'll say at the end, if you're really thinking about making spousal support claim, I urge you to speak to a lawyer about that. Okay, so we've talked about entitlement, we talked about quantum. Now I'm going to talk about duration. The duration of support is generally set by the length of the relationship. And generally, short relationships will attract a shorter duration of child support. I think of shorter relationships from 0 to 5 years. And in some cases, you may have relationships that we're very short, and maybe there's no entitlement, and maybe you're not even talking about duration. If that's the case, if you think that's, again, speak to a lawyer about whether your relationship was significantly short enough to maybe warrant no entitlement. The shorter relationships attract the shorter duration because there's likely little to no sacrifice made, and little to no reasons for compensating the other, because you just weren't in the relationship long enough, probably, to make significant sacrifices and give up some things that would otherwise enrich you monetarily. Medium relationships, I would call those maybe more 6 to 15 years, or maybe closer to 10 to 15 years. These relationships are trickier, as I say in the slide, because you will have folks who, 10 to 15 years, 10 to 19 years, that's not an insignificant amount of time. That you will probably have, not insignificant sacrifices made. You may have, sorry, I was just looking at the chat. You may have folks who still have a strong needs-based claim. So in here, you'll probably see more of the arguments from both the needs-based side and the compensatory side. In longer relationships, what I would call 20+ years, the duration is usually what we would call indefinite. There's no fixed end to it. And I can understand that would, if you tell that to a client, or I tell that to the public, that would make your throat close up pretty quickly, thinking I'm going to be paying spousal support the rest of my life. That is not quite the case, right? It's an indefinite amount to recognize the years, many years of probably sacrifices made by the one spouse, the raising of the children. Really, there will likely be a need to recognize that the other party needs to be compensated for the roles that they played in the marriage or in the relationship. This is not to say that it would go forever. There are, folks retire, they're allowed to retire, and when they retire, they're, as I'm sure folks know already, your income is significantly reduced upon retirement. So upon retirement, so long, and these are other factors that you would have to speak specifically to a lawyer of your own about. If you retire at what is probably a commonly accepted retirement age, then you probably have a good argument to either terminate spousal support or significantly reduce it. That does not mean, though, if you are, say, 50 or 55 and you have a spousal support obligation and you want to end it by retiring, the law may push back on you there. If you're in a specific industry where it's not common at all for folks to retire at that age, then the court would likely say you're going to have to keep paying. So you can't, there is an end to it or a significant reduction. However, you can't necessarily take advantage of that by just retiring when you want to. As I've said throughout a couple times, I strongly encourage those who are trying to navigate spousal support issues to speak to a lawyer. Because it's, like I said before, and we'll say again, it's probably one of the more legally complex, or as I say to the students, more slippery, one of the more slippery concepts in family law, because it's not like child support again, where you're just looking at a chart and finding where the rows and columns meet up. So independent legal advice, for those who don't know, it's typically 1 hour of a lawyer's time to give advice on a specific issue or issues. Some of you who may have called a lawyer before will know that sometimes you can't get in for independent legal advice without them asking for a lawyer asking for a retainer, and that's perfectly understandable. But you can call and try to see if a lawyer is willing to give independent legal advice for 1 hour instead of perhaps you having to dispense with retainer money. So I encourage you to call around if possible. You can also contact Legal Aid Ontario. The number there is on the screen to see if you qualify for a certificate to take your lawyers on the legal aid panel. For those folks who don't know, a legal aid lawyer, as you could commonly call it, does not work for legal aid. They contract to work for legal aid, and they sit on a legal aid panel where you can get a list of lawyers online who are on the family law legal aid panel in your area. And if you get a certificate from legal aid, you can take that to them for advice or whatever legal aid has given you a certificate for. The other option is you can contact the Lawyer Law Society Referral Service at findlegalhelp.ca. My understanding still is at the very least you can get 30 minutes of free legal advice and a referral to a lawyer in the area who can help on whatever your issue may be. As you can imagine, 30 minutes is probably not a lot of time to send you on your way, but I think we can all agree it's better than nothing. So I encourage you to do that. You can also go to Steps to Justice, their website. If you Google Steps to Justice, it will be the first hit that comes up. And they have just Steps to Justice has all manner of general advice on different legal issues, and there should be information on there with respect to spousal support. You may find it helpful, you may find it repetitive if you just sat in on this Zoom public legal education. Okay, so that is the general and basic advice or information with respect to spousal support. I'm going to stop sharing the screen, but just remember, if you have any questions, keep them general because I can't give specific advice. This is a public forum, so there's no confidentiality. And we'll just go from there. Okay, so I will stop sharing the screen. I think there's a couple of chats there, so I'll have a look at that. So, question from Facebook. If the other party doesn't live here and is not citizen but was permanent resident during a period of time, my understanding is that someone's residency really doesn't matter with respect to spousal support. It may impact where you can bring the proceeding if you have not ordinarily resided in a certain jurisdiction. Specifically, if you were in London and you had not resided here, ordinarily resided here, you wouldn't be able to bring a claim in London. But you're subject, this person who doesn't live here, if you were to bring a claim here and you were able to, it'd be subject to Canadian law. Is Canadian law considering any other support system that could apply to husbands and wives, such as Islamic law, Sharia law? How can we prevent the parties from providing misleading information? I don't know that question, I'll be quite frank. I don't know of any other support system that is being put in place with respect to spousal support and Islamic law. What I would just probably reiterate is the law that controls here is Canadian and Ontario law. So if one has the ability to bring a claim in Ontario and in Canada, they would be subject to those laws. So you'd have to get further advice to see if further advice from a lawyer to see if a claim can even be brought here, or a matter can even be brought here, depending on where everybody has resided leading up to this moment. And I wouldn't be able to answer that question anyway, because that's getting more into specific advice. Third question, do you know if you can get help from student lawyers if you have a family law trial in September? I can't answer that specifically. All I can say is, well, one, if you need a lawyer and you can't afford one, you can call legal aid. If you don't apply for legal aid and you are still perhaps on the bubble with respect to financially qualifying, you can call Community Legal Services to see if we're taking clients at that time and if you qualify. But beyond that, I can't answer that question specifically. I'll just wait a couple of beats to see if there are any more questions. Okay, I see there are no more questions. So I'm going to end the Zoom. I want to thank you all for attending. Great questions. I appreciate you sticking around. I know Rights and Responsibility Awareness Initiative will be, I think, posting this so it can be watched later. I know we will be. I've recorded this. So on our YouTube page or account, I've got confirmation that our AI will be posting it later for those to watch. If you want to watch again, I encourage you to do so, just so that you're armed at least with the basic knowledge. Thank you, folks. Have a good night.